we can start the meeting.
Yeah, I was about to say, can we start? I would request that as we'll be proceeding, members must open their videos when they are interacting. Hence, we'll be live on our media platforms. I want to take this opportunity and declare the meeting opened. Greetings to honorable members of the committee, National Department of Agriculture, Land Reform and Rural Development, Department of Agriculture, Rural Development and Land and Environmental Affairs, legislature staff, members of the public at all our social media platforms, and stakeholders present. This is my first meeting as the chairperson of this committee. I would like to welcome everyone present at this visual platform, at this visual public hearing. My name is Begitemba Lubisi, the chairperson of the Portfolio Committee on Agriculture, Rural Development, Land and Environmental Affairs. As the yes,
is Honorable Mkabela here?
Yes, Honorable Mkabela.
I heard you requesting us to switch on our videos when we're on the platform, but we can't see you here. I don't know whether it's
you can't see me, Honorable Mkabela.
Yeah, it seems like your video is off. Thank you.
Okay, thank you. I hope you can see me now.
Yes, Chairperson. Yes.
Okay. I was at item number 1 of our agenda. I was saying my name is Begitemba Lubisi, the chairperson of the Portfolio Committee on Agriculture, Rural Development, Land and Environmental Affairs. Today, as the Mpumalanga Provincial Legislature, we are pleased to continue involving and encouraging the people of Mpumalanga to participate in this legislative process. I will allow for the second item, which is introduction. I would like to allow members of the committee to introduce themselves.
Thank you very much, Honorable Lubisi. Honorable Shop, the Chair of Chairs and a member of this Portfolio Committee. Thank you very much.
Honorable Chairperson, I'm Honorable Weber from the Freedom Front. I'm a member of this committee.
Honorable Chair, Million, member of this committee.
Thank you, Chairperson. I'm Honorable Mkabela, member of this committee.
Thanks, Chair. Honorable Dinamo Fukeng, member of this committee. Thank you.
Good afternoon, Chairperson. I'm Honorable Trudy Frovia Morgan, a member of the committee. Thank you.
Thank you, Chairperson. Norama Tangu, a member of this committee.
We are done, Chair.
What happened to our chairman?
Chairperson, your mic, you have muted your mic. We can't hear you.
Oh, can you hear me now?
Yes, Chairperson.
Yes, Chairperson.
Kungconywana.
Okay, the purpose of the public hearing today, the committee is facilitating a visual public hearing to enable members of the public and all affected stakeholders in Mpumalanga province to make oral submissions and participate in the legislative process of the amendment of the upgrading of Land Tenure Rights Amendment Bill. The mandate of Mpumalanga Provincial Legislature is to make law, conduct oversight on the executive, and conduct public hearing. There is no legislation that can be passed without the people of Mpumalanga, and the committee will continue to solicit inputs within the province in different districts from people who could not form part of the visual public hearing. We have therefore the National Department of Agriculture, Land Reform and Rural Development who will present the amendment of the upgrading of Land Tenure Rights Amendment Bill. Thereafter, stakeholders will be given an opportunity to ask questions and make their inputs. I now hand over to the department. Thank you very much.
Thank you very much, Honorable Chair, and good afternoon to honorable members. My name is Serlo Ramasala. I am part of a team in the department that develops legislation, and we must apologize upfront that we are not able to upload the presentation from our side. We are advised that members have copies of the presentation, and that Ms. Chulan was also going to assist in uploading the document on the screen. And secondly, Honorable Chair, that it is our pleasure once more to share the document with the Portfolio Committee and members of the public present. As the honorable members will see on the screen, the presentation is fairly short. The presentation outline firstly deals with the introduction, and the introduction is basically about the Principal Act that we're seeking to amend, and then we deal with the two court cases that have necessitated the bill, and then we deal with the sections of the Principal Act that are affected, and then we discuss the bill briefly, the provisions of the bill, and then indicate briefly again the amendments by the Portfolio Committee of the National Assembly to the bill as introduced by the department, and then make some concluding remarks. With regard to the Principal Act, in the introduction, the Upgrading of Land Tenure Rights Act is a 1991 Act which was passed with the sole aim of upgrading the land rights that people have from deed of grant or permission to occupy into title deeds. The members will also be aware that as it is a 1991 Act, it means it was passed at the time when we still had former homelands, the independent and not independent homelands. And of course, in 1998, the Principal Act was made to apply throughout the Republic, with the exception of 3 sections which dealt with communal land. That those are sections 3, 19, and 20. In the main, the Act deals with urban land tenure. That is the land tenure that obtains in the former African townships in the main. The cases that gave rise to the bill, as I've indicated, are mainly two of them. The first one is what we refer to as the Rahube matter, which arose in a township in Pretoria, in Mabopane, where a township house was the subject of a dispute where the owner who got deceased left the house to her children. And then in terms of the proclamation that provides for the rights in respect of that foreign house, the proclamation that is provided for in the schedule to the Principal Act, the township houses could only be registered in the name of a male person. And then what happened in this case is that the male person in whose name the deed of grant was issued sought to sell the house, and in the process tried to evict his sister. And the sister challenged the conversion of the deed of grant, which was provided for in terms of section 2 of the Principal Act, to the extent that that section allows the holder of a deed of grant, who is a male person, as I've indicated, to dispose of the house. And the court agreed with the sister that the section 2 of the Principal Act that allows for automatic conversion from a deed of grant into a title deed to the exclusion of women is unconstitutional. That was the first case. As I've indicated, in the schedule to the Principal Act, reference is made to Proclamation R 293 of 1962, which is the regulations for the administration and control of townships in black areas. It is these regulations which provided that only male persons could have deeds of grants issued in their names to the exclusion of women. The second case deals with section 25A of the Principal Act, which deals with the application of the Act. What the section provides for currently is that although the Act is made to apply throughout the Republic, members will recall in my introduction I indicated that when the Act was initially passed, because it was in 1991, it did not apply to the former TBVC territories. And then also it did not automatically apply to the former homelands, which were not independent at the time. But what has since happened is that the 1998 amendment introduced a new section 25A, which provided that the whole Act, with the exception of sections 3, 19, and 20, applies throughout the Republic. Now, what happened in the Sengu matter is that a company called Teba Property Trust, which had been issued with a certificate, permission to occupy certificate in Sengu municipality in the Eastern Cape, sought to convert that permission to occupy certificate into a title deed in terms of section 3 of the Principal Act. Members will remember that I have said that section 2 of the Principal Act deals with the conversion of the deeds of grant into ownership, that is for the township houses. And then section 3 deals with the conversion of permission to occupy certificates, which are certificates that are ordinarily issued in communal areas, into title deed. Now, Taba Property Trust sought to convert its permission to occupy certificate into a title deed, and then the municipality refused to agree to a conversion on the basis that Section 3 of the Principal Act, it does not apply in the former Transkei, where Sengwe municipality is situated. On the basis of that, they refused to confirm the conversion, and then Taba took the municipality to court on the basis that Section 25A of the Principal Act, which states that Section 3 is not yet in operation, is unconstitutional on the basis that it violates their right to equality. In other words, their right to protection of the law and their right to equal benefit of the law. The court agreed with Taba Property Trust and declared Section 25A unconstitutional. So those are the two cases that gave rise to the bill that is before the honorable members and members of the public today. And then the sections affected by the court cases are basically Section 2, which deals with the automatic conversion of deeds of grant in respect of 4-roomed houses in African townships into ownership, and then Section 25A, which deals with the application of the Act. This is the section that provides that Section 3, Section 19, Section 20 of the Principal Act are not applicable in certain parts of the Republic. This is a section that was challenged by Taba. Now, what the bill provides for is to amend Section 2 and then Section 25A with regard to Section 2, to amend Section 2 and do away with the automatic conversions that exclude women from becoming owners of 4-roomed houses in the townships. And then Section 25A is also amended to ensure that Section 3 is read out of Section 25A so that it is made applicable throughout the Republic. Now, how the bill seeks to amend the Principal Act with regard to Section 2, what it does, as I've indicated, in terms of Section 2, as it stands currently in the Principal Act, if I am the holder of a deed of grant, in other words, if with regard to a township house, the house is registered in my name, and as I've indicated, houses could only be registered in male persons' names. If I'm the holder of a deed of grant, Section 2 automatically provides that I can approach the deeds office to have that deed of grant converted into a title deed. Now, the court said that process of automatic conversion, because it does not afford interested persons an opportunity to object to the proposed conversion, is unconstitutional because it violates the rights of interested persons, in particular women who historically, or who in terms of the proclamation that I referred to, or have not been allowed to become or to have township houses registered in their names. What the bill seeks to do is to introduce a process in the Principal Act that will allow persons who were previously excluded and then an opportunity to object, and then also to instate they themselves apply for conversions. How we do that, we have introduced the provisions that require a person seeking to convert a deed of grant into a title deed to make an application to the minister, our minister.